Всем привет! Сегодня
Good afternoon, everyone. Positive Technologies Fest is a great event for me because I always learn something new, something useful. And today it's a double occasion for me because we have a huge legal panel discussion. This is the first time lawyers were invited to take part in a PhD Days Fest. And this is one of the ongoing trends. Being a lawyer, I cannot help but notice that oftentimes we get approached with questions by IT guys, and this is a trend that we've seen in the movies. Because if you watch the movies, 20-year-old movies about hackers, lawyers were not present. Only internal conflicts were highlighted. And right now, what we are seeing is that any TV series about the IT industry or any movie stars lawyers or trials where lawyers are always involved. So without us, you will not make do in the IT world. I know lawyers can be boring, so I have three important promises to make before we start. The first one is going to be as follows. We are not going to use any legalese. We're going to speak plain Russian or English. We will only discuss real cases from real life. We will definitely not discuss something hypothetical. And last but not least, we will share some tips and tricks and practical pieces of advice for you as takeaways so that you can use it in your daily activities and your work life. Stay tuned, it's going to be interesting. So how come lawyers are so relevant for IT companies? Because, IT companies need to protect their reputation, IT companies need to protect their freedom, and IT companies need to protect their intellectual property rights. Let's start with reputation. Because what we are seeing right now is as follows. Any negative or positive news significantly affect companies. If it's a public company, then a negative piece of news will have a double impact. I'd like to pass on the floor to Alexei, who is an independent expert on cybersecurity. He runs Post Lukatskova, which is a famous Telegram channel, and he knows that a published piece of information on an attack can have a direct influence on your own fate, the fate of their company. And the way it works is as follows. On the one hand, a cybersecurity consultant should do the good for the world. But on the other hand, if he or she publishes information on the leak, then it delivers a critical blow on the reputation. Alexei, where is the boundary between the public interest and the reputational risks of a specific company that has been hacked? Thank you so much. For starters, I just wanted to state a disclaimer. Right now, well, you've introduced me as an independent expert and a member of Positive Technologies team. I'm going to speak in my capacity as an independent expert. I have nothing to do with Positive Technologies right now during this panel discussion, because oftentimes experts who are quite public, who are famous public figures, who run their blogs, who address various conferences or have their own Telegram channels, are still perceived as the staff of their companies, and I'm only speaking for my own self. So keep in mind that during this panel discussion, I'm going to act as an expert, as an independent expert. So being an independent expert, I faced the following situation that can affect any public figure. For instance, I published, actually I reposted an info about a hack of one of the national operating system developers. There was a personal data leak after the hack. So the customer database was leaked, the employee database was leaked, and that was a proven fact, though. And, no one denied the leak. But given the fact that the company I have written about in my TV channel, we're talking about several dozen thousand of subscribers, they said that it was defamation, and they thought that I undermined their reputation, so they went to court against me. They went to a court of arbitration because they thought it was potential damage to their business. It's been 2 years since we've been in court with this company, and
было выиграно 3 суда, собственно, первый суд, апелляция, кассация.
So the very first appeal was just over, and now we're gonna go to the Supreme Court, and this is gonna be the very first case in the Russian legislation when a person goes to the Supreme Court because of the defamation charge. And the Supreme Court judges will probably learn a lot about cybersecurity and our domain, which is good on the one hand, but what's bad is that the person who is out here to talk to the market about the vulnerabilities and the imperfections in the protection system that can affect the interests of each and every one of us, because we are all customers of one or other company, and our personal data is processed by multiple companies. Data leaks are possible, and of course companies don't want that to be made public.
Not to make this fact public, and should it get into the public domain, they are trying to also interfere. Fortunately, this is not 1990s. No one, took me out to cleaners, but court is a court, and it's not a pleasant experience if you're not ready for it. Fortunately, it's not my first time dealing with court proceedings. I actually enjoy that process because you always get to learn something new. It's a new experience, especially if you have time for it. So it was educational. But once again, if you have not ever come across this yourself, it may probably serve you as a sign that you should never ever talk about cybersecurity, especially problems with cybersecurity, in the public domain. Because if you do not talk about problems in cybersecurity, this may create the illusion that everything is fine. But actually, since we are here at the PhDs, we cannot keep silent about challenges of the cybersecurity space. So it's been 2 years, and there are certain lessons that I learned on the way. Hopefully, within the next few days, maybe a month, this process will be over, because the Supreme Court is the highest judicial instance in the country. You can't go further than that. Unfortunately, we were able to win 3 cases before in the Supreme Court. Hopefully, we will win this time again. But here are the takeaways. If you are a public figure, you have to separate yourself from your employer. If you speak on your own behalf, you have to somehow record that, because if you have a blog, you can add this information to the heading. If it's your social media page, you can also add this information to the header. And you can always tell the mass media, the journalists, that you are expressing your own point of view, a personal point of view. It has nothing to do with your employer. It has nothing to do with you. As a matter of fact, you are protecting your employer by doing that, because the employers will not be happy if there is a criminal or an administrative case against you, and the employer will be smeared by the discussions around it. And yes, it can certainly affect you as well and your career in the company, and the employer may want to part with you, but fortunately positive is on my side because they are also all in favor of public discussions of the problems and challenges. But once again, I am now speaking as an independent expert. So the first rule is separate yourself from your employer, and secondly, always publish data that has been proven. So if there is a report of an incident, you have to double check that indeed something like that happened, you've got evidence. If it's a leak, then you have this sample, and you understand that it's indeed a leak, it's not a compilation. I understand that for non-experts, to distinguish between a real sample and a compiled sample would be a feat, but given that very soon, on the 30th of May, is it? The amendments will come into effect to the criminal code for illegal processing of personal data. This may involve liability for you. So again, if you are investigating and you are working with samples and there are leaks, there may be consequences. Hopefully, my case will be before the 30th of May, but you will have to be mindful of that in the future. So before you publish anything, double check. You can always repost, but even repost today may result in certain legal problems for you. Another important message that I feel like I need to share with you: if you feel like you are in the right and you publish information, you are standing for truth and for openness, then you have to stand by your words. If there is a publication, then there is pressure put on you and you stand back, you step back. This will not look good. Of course, it will be good for those who put pressure on you, but for you, this will lead to depression. Have you attended yesterday's sessions? Here we talked about depression and the symptoms of burnout and the fact that you need to drink herbal tea instead of drowning your grief and sadness in a glass of whiskey or cognac. So any depression leads to burnout. So if you are certain you are right, stand by your rightness. If you are not certain, don't even start. And the most important takeaway here is if you work in a company and if you know that if you know that there is a complaint against you, you have to inform your lawyers. Because indeed, historically, the attitude to lawyers is quite an uneasy one. They are bookworms. There is security for security people. They only do security on paper. And these people, too, they work with paper. They They are very conservative. They hedge their bets. They play safe. So your employer will be able to protect you if the employer knows what's going on, and the employer, by protecting itself, will protect you as well. The lawyers of the employer are your friends. They are on your side. So lawyers will be your helpers. Because on your own, most likely you will not be able to do much. I'm not sure that all people here are very versed in criminal procedure, criminal code, in administrative procedure, administrative code. And you should also take into account the actual legal practice. Without lawyers, you will not stand up too much. So my takeaway, my lesson learned is without legal support, cybersecurity today is not possible, especially these days when the incidents are mounting and there will be more and more of them in the future. We are already embarking not only on the domain of IT and hackers, but all of this is potentially touching upon some criminal laws, and especially if it's we're talking about international businesses, an offense in one country may not be criminalized, the same deed may not be criminalized in another country, and even if you leave, say, one jurisdiction and you go to another jurisdiction, you may be put under legal pressure there, even if you didn't have any in the initial jurisdiction. So again, please be mindful of that. Alexei, thank you so much.
Обувку компании, которая
Now,
стала, скажем так, жертвой публикации.
let's put ourselves in the shoes of the company that became victim of a publication. Anya, we are not a company that was victim of a publication. People may think that this previous story has anything to do with us. Well, no, this is a hypothetical question. People from your PR department come to you and say, "Hey, Anya, there is this well-known blogger who wrote something on Telegram." No, I don't mean you. What do we do? He wrote something bad about our company. We bring him to court, or what's the best course of action? Well, we don't go to court often. That's the position of our company. We don't we're not very litigious, especially if it's people on the other side. We try to come to an agreement and get to the root cause of the problem. Pentest is a huge ecosystem, and we've got different methods and techniques of cybersecurity, starting from mobile communications all the way to movie production. So bloggers love our company, quote unquote. They write often about us, but usually we get in touch with the blogger and we try to find out what were the reasons, what drove the blogger to write that about us, why and where is the information coming from. In 95% of cases, as we are negotiating, we usually find out that that was personal opinion of that particular blogger that can be changed or that can be affected by if we were to provide an alternative story. So we do try to share documents or evidence disproving what the blogger believed to be true. So again, 95% of cases it works. And bloggers, we had cases when the bloggers would really write a...
адекватный блогер. У меня был кейс очень неприятный, это до вот этого судебного иска.
Would write a refutation. I had another case several years ago. There was this incident about 100 million personal data of Russian citizens leaked. Ведомости wrote about that. Then Kommersant wrote about that. And then after 3 days, I wrote about it. After all the business media have already covered the story, I decided to write about it myself. And the company who serviced the organization that lost the data, people know me. I'm known in the market. I mean, security people know me. It's very difficult not to be able to find me, to talk to me, to come to an agreement like MTS. It's a great bit of advice. Talk to the writer, find out what drove the writer to write that. But instead, again, I wrote that post in my personal blog. Nobody got in touch with me. Instead, people started calling one deputy general director, the other deputy general director. There were demands to fire me, to punish me. But if people put pressure on other people, any psychologist will tell you that the normal reaction was to get on the defensive and respond in a similar fashion. So instead of trying to come to an agreement, looking for an explanation, instead I hear that you will be fired, we'll fire you, and they're not talking to me directly, they're calling my superiors. So of course this is going to cause my very strong reaction. So again, if you're not happy with what you read in the blogs, do not try to put pressure on the writer via their superiors. Talk to the writer directly. So in that particular situation, unfortunately, things got worse. I keep working for positive companies on my side, and this other people who were trying to put pressure on me. Unfortunately, they are, well, less lucky, let's put it this way. No, I think that we need to understand the particulars of the case. If there was a leak, then there was a leak. So probably you should be fighting not the person who wrote about the leak, but the leak itself.
Все мы помним замечательный эффект Барбары Стрейзанд, который...
We all are aware of the Barbara Streisand effect. She sued the photographer who published the photograph of her mansion, and then everyone got interested in her mansion that she wanted to keep private. So the ability to communicate with bloggers leads to, well, inability rather, leads to a conflict, and it's definitely not a win-win situation. You have to be ethical on both sides and consider the consequences. So we talked about reputation, now I wanted to turn to freedom.
Делают люди, вовлеченные в кибербезопасность.
In the context of what people in cybersecurity do,
Вспоминаем слова «хакер».
when we say freedom, we remember other words. Hacker,
Свободный русский язык, и вижу, как
language,
трансформируется вообще смысл
the
за последние десятилетия.
freedom of expression, the freedom of language. Hacker, you know that in the past, hacker, this word had a purely negative connotation, someone who breaks in and
Белый хакер и черный хакер. Я надеюсь,
generates damages for people and companies and governments. And now we've got white hackers, black hackers. Hopefully, white hackers will evolve into, I don't know, investigators perhaps, or researchers, those who find vulnerabilities. In the current legal paradigm, there is just one step, separating a black hacker and a white hacker. My question is to Dennis. He is a criminal court lawyer. In your practice, when can hackers be brought to criminal liability? Well, hello everyone. Of course, I need to refer to the criminal code because everyone is interested not what for, but for how much, right? What's the term of imprisonment? In terms of white hacking, there are 3 articles pertinent to their activity. One is 272. Without keeping things clear, illegal access and copying the information. So you are a white hacker and you get in and copy the information, but you didn't have the right to copy the information. There wasn't a contract, there wasn't an agreement with the
Если вам неслыханно повезло и вы
with the owner, with the rights holder, then it's up to 2 years. But if this info contains banking, commercial, or medical secrecy data, then you can go to prison for up to 7 years. There is another article, 273. 273 is coding software for the purposes of unlawful penetration, up to 4 years. Up to 4 years, and that's the minimal imprisonment term. But if the company's operations stopped for a long period of time, or if access was obtained to commercial secrets, commercial or banking secrets, or if you block the computer of an individual and this computer contains healthcare data, then it's up to 7 years in prison. And the last thing, for this personal data, if you copy someone's personal data, and this brings us back to bug bounty, obviously. So again, if during bug bounty you copy to your own computer the name
туда же.
the surname, the name, the patronymic of the person, and his/her phone number, or tax-based ID, or other personal data, then it's up to 4 years in prison. And if you were not lucky and the person's personal data you copied is minor, below the age of 18, then it's up to 5 years in prison. And should it happen so that this data was uploaded not onto your hard drive or not onto your Yandex.Mail or wherever, but if you keep it on Gmail or Drop, then it's up to 8 years
Ну и если вдруг
in prison.
вы это сделали
And if
неоднократно со своими однокурсниками,
you do it repeatedly together with your
таким образом закон это
co-students,
оценивает как организованную группу.
this will be treated as an organized criminal group. Then what is it? Yeah, you guessed right, up to 10 years. And then there is another component to this, organizing these activities, organizing the coding of such software, etc., etc. So that's up to 5 years in prison.
Теперь интересно
Now,
узнать, как мне
that's
попасть в этот ресторан.
a very diverse menu. How can we avoid walking into this restaurant? We have known Dennis for a long time. I'm the awful person who actually instigated the case, and I got it through to 2 years in prison. That was 3 years ago. My personal data was disclosed, and this led to something bad happening in my life. I managed to get this person tried and sentenced to 2 years in prisons. I'm sitting here in front of you. It has nothing to do with the company where I work. It was my personal data, my private life. But yes, I put this person in prison for 2 years. 137, that was 137? Yes, that was 137, Article 137. Usually Article 137, they are the people, it's usually the exes who are tried under this article. They are the ex-girlfriends or boyfriends who publish the nude photographs of their exes. 271.1, unlawful access to personal data. What's the gist of this article? Well, the key word there is unlawful. Now, why do you need lawyers? Well, you need lawyers because lawyers know how to write policies and contracts that enable white bug bounty. I'm here because I was involved in developing post-technologies policies related to the risks of white bug hunters. And we really do everything we can to make sure that you are not facing any criminal liability. If you are ever involved in any activities related to penetrating third-party systems or computers, first of all, you have to be aware that wherever you go, you are bound to encounter personal data. So if you enter a system and you start copying anything, there is a high risk that you are copying some unauthorized information, and it means the risk of criminal liability. So before you penetrate anything, before you break into anything, you have to be sure that you are entitled to do it. Even during pen testing, these risks are also viable, and before entering anyone's system, any third-party system, you have to make sure that you have the right to do so. There should be a contract, or someone is organizing bug bounty and you must have a participation contract. So, but this contract, this paper should say that you have the right to copy and to store on your side. It's like washing your hands before you eat. It's the same kind of hygiene. And going back to personal data.
Другой информация. Значит, это копирование.
Now, copying, that was about copying of personal data. As to, and actually I know that, like,
который может каким-то образом
say, take a Telegram bot. There are Telegram bots that is collecting data. So if you modify an existing software to collect data, again, this is a risk. You should have authorized access to the system with which you work, that you investigate. It must be recorded, right? Must be recorded somewhere, must be registered on the file.
можно было установить, что действительно
If it's a virtual contract, you must download the file that will confirm your right to intervene in the operations of a particular system. If you're doing a pen test, you need to get a scan from the official email of the organizer of the pen test, of the customer, and download it to your email box. You need to make sure that you have all the paperwork. Okay, I have another question. Say, it's an ethical hacker doing everything legally, got the consent of the rights holder, but say that hacker receives a summons. What do? Leave the country? Flee? Well, if you have not done anything illegal, there is nothing to be afraid of in our country. This is a state of law. And Alexei,
если вам поступил вызов на допрос,
don't worry too much. Well, again, if you receive summons, it doesn't mean that directly from the police office you will be sent to a prison somewhere in Siberia. There are lawyers. They are investigators. They have the right to call in witnesses or to call in people who they think may be associated or involved with a particular crime. So if you receive summons, then first of all you need to find out what is the reason for this call. You can call the investigator. Well, first of all, you make sure that these are not fraudsters. It's a real investigator. And so you call the investigator and you say, what is the reason for this summons? Because I need to be prepared. I need to review my logs. I need to review my email. I don't want to waste your time. Let me come to you with proofs in my hands. Because this is important. I mean, your words are your words only. I know that you are all law-abiding citizens, but if you bring proof, if you bring evidence, then this will be better. So once again, if in your email you've got the consent of the customer to interfere in the system, if you can recall the algorithm of the sequence of events, everything that was happening, how you got invited, say, to participate in this pen testing or whatever. So once again, you can review all your information. And the case that we had only 3 months ago, there's the company. They collect and analyze information on people. And a certain special service came to this company. They found that employees of the company were storing information that before this article 173 prime came into effect was okay to collect, but now even if you collected personal data 3 years ago and you keep storing it on your hard drive, this now may mean criminal liability for you. So I suggest that you take a closer look at your gadgets. Well, the best thing to do is to replace your hard drive, because all InfoSec people here will tell you that no formatting of the hard drive removes the data forever. I saw many expert studies. In criminal cases, even if there were 7 rounds of formatting, the investigators were still capable of retrieving the original data. So that was a device from one of the leaders in information security. security. They were totally mad about information security. So 7 rounds of formatting, write, delete. So even after 7 rounds of that, they were able to find information on your hard drive. So if on your computer, some personal data of people is stored on your computer and they never consented to sharing their data with you, automatically you will be brought to justice under this article of the Criminal Code. So once again, store all the proofs, delete the information when it's no longer relevant, when it's no longer necessary. You got the money, I don't know, you made the report, you can say goodbye to this data, especially if it's personal data. Can I have a question?
Гипотетическая ситуация.
Well, hypothetically speaking, let's say I go to a website of a company and I detect a vulnerability that can have an impact on my personal data. Can I report the vulnerability to the company, or will it be considered as, ransom or extortion? For instance, if the company is not a participant in the bug bounty platform, that means that it's illegal processing, because if I got access to a personal account of another user, that means that I got illegal access to personal data. Does that mean that I cannot report the vulnerability and I cannot share this information with the public? I cannot report it to the company because it might be considered extortion, and I cannot report it to my journalist friends so that they can share it with everyone else, thus increasing the cybersecurity. Well, I heard at least 4 offenses in your short speech. That's why I'm asking, because people call me and say, they only they have a 3-character password on this website that protects my kids' personal data, and everyone ignores me, and I'm worried about the cybersecurity of my own child. What do I do? And I don't know how to respond to a request like that. Once again, let me start from the very beginning. We do not acquire strangers' personal data, but if you get access to your own personal data, no, you happen to enter someone else's personal account. Alexei, hold on a second. If you're testing your own personal account to show how easy it can be hacked and then report it to the owner, that's normal. That's not an offense. This is your personal data. However, if you hack a personal account of someone else, of a third party, and if you see the personal data and you have to actually report the vulnerability, that means that you're going to store a third party's personal data, and that means this is an offense on the Article 272.1. Extortion, well, this is a different offense under different articles with different requirements and standards. And if you demand the money for not divulging the information that might be considered defamation and so on and so forth, you do not extort money, right? You are there just to report the vulnerability. But if someone demands the money for not telling anyone about the hack, that's going to be the extortion, and everyone was arrested under this article in the most recent scandal. What else did you mention? This is it, right? So I cannot report the vulnerability to anyone if I come across it by chance, right? Well, if you detect a vulnerability, if you go into someone else's personal account, if you did not copy the personal data, and if you just reported the vulnerability to the company saying, guys, you have this bug, I used this technique to enter, and I saw something which I'm not going to report to you, do the same, and you'll see that there is a vulnerability, please fix it. In that case, it's not an offense. But it does not mean that the company is going to fix it. Of course not. So, well, I did my job, I reported the bug, and then I don't care, right? Well, you can go to the Prosecutor General's office because this company breaches the law because it is obliged to safely store personal data. It acquires personal data, but it uses bad tools. Therefore, the Prosecutor General's office will have to double-check that. By the way, there is another case when the prosecutors just went to a website of an educational platform and said, hold on a second, you have several boxes and you don't have these boxes, you're getting a fine. So you can report the links to the Prosecutor General's office. So they will push the buttons, and they're a public authority, and under law they can do their own investigation, and then based on the outcomes they will force the company to do it. So under Article 272.1, a prosecutor is not liable. Well, you cannot imprison a prosecutor. Hold on a second. If I, as a researcher, send the data to the Prosecutor General's office, can I be incriminated for that? Well, I demonstrated the way it could be hacked. So it's illegal access, and the letter sent to the prosecutor proves that. Hold on a second. It has to be linked to the storage and processing. In other words, it's not just about illegal penetration. It has to have some consequences. Penetration with consequences. If it's penetration without consequences, this is just for fun. Right, got it. So it's a bona fide story. You can go to the Roskomnadzor, the supervisory agency as well. They also work perfectly well. If I may, I wanted to add a few words to that. What do you do if you get a subpoena and you have to go somewhere? Well, if it's linked with your professional activity, report it to your employer, and do not go anywhere without a legal counsel from your employer, because the liability is shared not just by you, but a lot of other people in your company. And a good company, an adequate company, will always find money for a lawyer, and they will provide you a lawyer. All companies have in-house or hired lawyers. Trust me, it's better to bring a lawyer along and he does nothing than vice versa when you come in without a lawyer and you say something wrong and you're gonna get a sentence for that. So don't hide this information from your employer. Trust me, a good employer is interested in getting all the facts straight and is interested in understanding you, especially if you are not at fault and if someone has been misinformed. Right. Let me add a few words to that as well. And let me follow up on what you just mentioned. Let's put it this way. If you work for a company that specializes in IT technologies, cybersecurity, and stuff like that, then any subpoena, any call from any investigator or a policeman or a prosecutor, if you're getting a fine for the fact that your dog defecated on a lawn, call the security guys. They will take a closer look at it, see whether it's critical for you, for the company. Oftentimes, we came across the following. A person is subpoenaed as a witness because, for instance, he listened to some loud music after 11 p.m. And then, all of a sudden, it turned out that he was interrogated by a totally different set of people. So you bear a responsibility for your own self, for your family, and for your company. So any call, any subpoena from law enforcement should be reported to your employer. And then the security department will check whether you did listen to Metallica in the middle of the night. In that case, you're going to have to pay a fine. Otherwise, you will get support, legal support. Well, our golden rule is as follows. If you get a call, call your lawyer, call your boss. We'll get all the facts straight. It's not a pop quiz, right? Go to the prosecutor as fast as possible. It takes more work. It takes serious analytics, and employers are interested in defending its employees, because we're talking about business reputation as well. We talked about freedom, so let's talk about IP rights. I saw an online meme recently. about an IT guy working remotely for 4 different employers. So it's a short video. There is a bookshelf, a table with a computer, and there is no bed, which means that this IT guy does not sleep at all. So, Nikolai, my next question goes to you. How do you discern between personal projects by IT guys and projects sponsored by the company? Maybe the company comes to you and says, well, your personal project is actually our own project. We have the IP rights for that, and we're going to sue you. Any cases from the Russian legislation and legal practice when there was no clear-cut boundary between the personal space and the corporate space? Thank you so much for the question. Actually, there are lots of cases like that, and all of them are based on a very obvious thing. If you get paid by your employer for doing things, then the IP rights for that belong to the employer. But now let's drill into in a couple of cases when it's not really so. Nginx, Igor Sysoev, and Rambler would be the first example. When the developer worked for Rambler as a system administrator, and the product was evaluated at $700 million. Rambler got envious, and Rambler said, well, he started working on this project when he still worked for us. Therefore, the IP rights belong to us. He did not have the right to set up his own company and then sell it as an exit strategy. So that was the conflict of interest. And to decide who was right, we had to analyze all the papers, and this is a very important bullet. Neither witnesses nor other types of evidence can prove the IP rights. It's the papers, and if you read the documents, it says that he was employed as a system administrator. What's the job description of a system administrator? It's administrating. It's not about developing new products. He was not there to develop app servers or do some research. So when they analyzed all the papers, they saw that it was not part of his job description. Therefore, the court decided against instigating criminal proceedings. The company tried to take him to a Californian court of law in the U.S., but they also refused to do that because there was no ground to punish a developer for the fact that he might have used his working laptop to do some personal, to develop some personal project, and then the project took off. He made money on that, and the company that employed him did not get a penny. That might be a case, and the Rambler and Nginx case is a proof of that. On the other hand, there are other conflicts and disputes when a developer, when he leaves the company, sets up a company and then says, this software piece is mine, and he gets a patent. But the company wants to take part in this patent as well. Again, you have to see whether he developed it as part of his job description. And by the way, as far as the patent is concerned, there is a caveat. It could be either part of a job description or specification requirements. And specification requirements, even if they were part of the labor contract, but outside of his job description, in that case, it will not work. It's not as obvious. On the one hand, in your working hours, you use your working laptop to develop something, and then you claim the rights for that. Then what did you get paid for? There is a paradox in the applicable Russian laws, and lawyers make much money on that, and there are lots of proceedings devoted to that, both in Russia and abroad. That's just one dimension. The second dimension pertains to the know-how and the commercial confidential information that an employee gets access to. And then when he goes to leaves for another company, he might want to use it again. And on the Article 183, there are lots of verdicts against employees who had access to confidential information, and then they would use the same information information when they start working for a new company, and then they get the sentence. The good news, we've been talking about criminal liability, imprisonment, and stuff like that. So I'm going to share with you two pieces of good news. If an employee acquires some skills, they belong to him or her. For instance, this person gets experience, you own it, you can use it later on. And the second piece of good news is Anton Mamichev's case. You might have heard about that. He brought to an employee his own outcomes, he used it, then he left the company, and the company kept on using these results. And the court prohibited the company from using it in the future. So if you had something that you brought to the employer, used it, then the employer does not get the rights to this property. What basic piece of advice would you give to an employer who wants to protect itself against, employees? And on the other hand, what piece of advice would you give to an employee who doesn't want to go to court to discuss the IP rights? Well, the matter is that for some reason in Russia we believe that IP rights is something that we need to divide. No, the rights can belong either to you or to me. And to a certain extent, this is true because we're fighting for exclusive rights and for the right to make money on that. However, unlike an apartment or a red Ferrari, intellectual property can be owned and used together without infringing on each other's interest. For instance, you can only drive Ferrari in turn, but you can use the very same database simultaneously. So I would suggest that the employer shuts the vacuum cleaner down, because the vacuum cleaner sucks off the intellectual property developed by the employees, and that demotivates the employees. The employees don't want to lose the IP rights for something that they develop. I know it's a very thin ice, but if an employer trusts the employee, they might say, if you develop something, we'll analyze it. If we're interested in that, we'll strike an agreement and we'll jointly use it. If we are not interested, you're going to get the rights. And if we get the rights, then we'll compensate you for that. If you don't want to live on a salary, then my piece of advice would be to you as follows. Read the job description and the labor contract carefully. If you are confused about something, clarify it and introduce amendments if need be. For instance, if you are to develop some control software, or if you are obliged to invent things, do you get the patent for that? If you don't ask stupid questions right now, if you are confused about a provision in your labor contract, that would mean that this bullet can be interpreted both ways, either against you or in your favor. And if the corporate lawyers are smarter, then it will be used against you. So don't be lazy, ask the questions. That's a bad piece of advice. And a good piece of advice is as follows. You can always agree on things. For instance, you might say, I want to launch this, let's do this together, let's put our relations on paper. Exactly, it's an open dialogue. When you are hired, an employee might say, well, simultaneously I'm going to be working on this, and that, or for instance, if you're already doing that, you have to disclose this information so that there is no confusion that these rights belong to me, these rights belong to you. And if a company is interested in a certain development, they might want to sign a license agreement for the employee to make money on that, to be able to make money on that. You also touched upon not just intellectual property, but the know-how, commercial, confidential information. And, intellectual property is not always gold. There are other assets that make companies' business unique. So my next question goes to Anna. what does MTS do to protect confidential information, know-how, and how do you explain to employees why they need to sign all these papers? What do you do, and how do you go about protecting all these things? And what policies do you have in place to protect confidential information? Well, I would be happy to share this information with you, but I'm not at liberty to say, I'm sorry, I'm not at liberty to share this kind of information with you. There are a number of papers that our IT guys sign, but we have 90,000 IT guys working for the company, so, you know, we're a huge company. And we have a paper for everything. We are weird that way. And we haven't been signing hard copies for a very long time. Everything has been automated. We are strong advocates of the IT technologies. We just tick the boxes by default. In other words, we have every prerequisite in place for the IT guys not to overdo things. But they have to sign a ton of various papers. One of the prerequisites is specification requirements in the automated system for developing things. So they get specifications, they familiarize themselves with the specifications, they sign off on that, they report the results, and so on and so forth. But we pay for the results of the intellectual activities. In addition to salaries, our IT guys get a compensation for handing over the IP rights. And the fact that they sign the reports is just another proof that they will get the money ultimately. As for the confidential information, we take every care to protect confidential information. When Denis listed the different types of communications, he also forgot the communications secrecy law, which affects all of us. If you have never been to a bank, banking secrecy law is not going to cover you, but you all use smartphones. Therefore, the communications secrecy law affects everyone, even small kids in Russia. Therefore, for us, you know, it's a very important topic, especially given the fact that you all use smartphones and your phone numbers are part of personal data. Whether we want it or not, it is so. Therefore, our security, a huge block of our security pertains to the communications secrecy. Our employees sign a ton of papers around that. We have encryption for data that is provided to third parties. We have confidentiality status for all of our papers and files. And in-house, we have a huge repository for storing code, just like any other IT company would. And we call it our in-house GitHub. And inside that GitHub, the in-house repository, we have an encryption component specifying confidential information. And the developers know that if this is confidential information, then they use the relevant classifier, and only a limited pool of people has access to such documents. We use watermarks as well. We use watermarks everywhere. The law is lagging behind the technology, unfortunately, and the confidential information law says that it's only the tangible means that should be watermarked. So in the past, you had to print out the papers, then the same law covered floppy disks, then USB sticks, USB memory sticks, and so on and so forth. So we have confidential code lines, watermarks, and elements that we insert and inject into the file headers. We have different ways, but there are two confidentiality work extremes: in-house confidentiality, and this is what we use to protect ourselves. But you also have access to confidential information of your customers for whom you develop stuff. So if you develop something, or if you're pen testing banking papers, you automatically get access to papers that are covered by the bank secrecy law. Therefore, you have to comply with it. Any company that develops anything for someone who has confidential information has to protect a third party's confidential information, not just its own. By the way, I wouldn't say that we have many criminal cases on confidential information, and we don't have that many cases in general because you know, you have to have a list of confidential information. You have to get all the signatures. You have to have an internal paper. Usually, you lack something, and if you lack something, then there is no case that you can take to a court of law. And every case does not stand in a court of law because of a lack of some paper. Therefore, if you value your reputation, just stick to the list, comply with every single bullet. If you have access to confidential information, read the small print that no one usually reads. It's a bullet about confidential information. Even lawyers do not read this bullet. This is the most useless bullet after the force majeure provision. But if you sign a contract that covers access to confidential information, then you hire a subcontractor and you don't report that to the subcontractor. And we all do that. We all hire subcontractors. And if you omit signing a confidential agreement, NDA with them, then you break the law. There is civil liability, criminal liability for that. And in Russia, the most infamous case was the Yandex developer of 2016, who was imprisoned for 2 years for stealing Yandex's code, and the element of the code was linked to their search engine. You know, it's common knowledge. If you have collaborated with Yandex, you know, you've heard about that. He wanted to get $25 million for this piece of code. Ultimately, he was imprisoned for 2 years, and he was banned from seeking a job with an IT company. Another case was when a guy was imprisoned for 10 months, and he would have to pay 10% of his salaries to the plaintiff. And 17 million Russian rubles was the sum of money that was awarded to the plaintiff because the developer provided access to the beta version to a third party. So the company tested the product, and then and it also simultaneously provided access to everyone to do the same. So the fine imposed was 17 million Russian rubles, which is a huge amount of money. So take confidential information seriously. It's a very important tool, and confidential information leak is easy to prove, especially if all the elements are in place. Let's imagine the following situation. An employee works for a company, signs all the papers, agrees that he will not disclose the information 5 years after he leaves the company. Then he's employed by the rival, and the rival starts using your commercial confidential information. Would you take the rival to court immediately, simultaneously reporting the former employee to the law enforcement, or would you just choose one option? That would depend on what rival we're talking about. And that would depend on the nature of the confidential information. If the confidential information was linked to cybersecurity or payments of our subscribers, of course we would go to the law enforcement, because they would be able to get the proof that we cannot get access to. If this is a different type of confidential information that has nothing to do with interests of our customers, we would file would file a case in a civil court of law. It's like using your code. Unless you get access to their code, you will never be able to prove it. So that you need to get access, and to do that, you have to go via law enforcement. Without them, it's almost next to impossible. Well, I have the following question. You all mentioned subcontractors and the fact that we work with subcontractors, and there is a section on confidential information that we sign with some contractors. What if it's the fault of a subcontractor when there is a leak? And since do we shift the blame to the subcontractor, or do we bear the burden of responsibility? Because it's part of the contract, but you cannot prove anything. Well, the customer will come to you and demand the money from you. Trust me, customers don't care about whose fault it was. Therefore, they will claim the money from you. You can, claim the money back from the subcontractor. How do we make sure that it can be done? The contract should state that you can readdress file a recourse claim with subcontractor. Sorry for the legalese. If there is no mention, there is no direct mention in the contract, then you have to go to court, and it remains to be seen what happens in the court of law. You have to select the contractors who don't make mistakes. Have you ever seen a subcontractor like that? Well, these are your risks, and that's why you act as a master contractor and hire subcontractors. Actually, I have just one brief question about AI. During the last 3 days, we talked about this topic, so I'd like to address this question to you. Usually, the lawyers get the following question: how am I going to get punished? Let's say someone gets the results, and the results are published. Who's going to be responsible for the failed AI?
Раз искусственный интеллект — это подрядчик, то пусть все равно я несу ответственность, если у меня нет договора там с OpenAI, с Яндексом, с Сбером, Гигачатом и так далее. То есть если в оферте этого нет, которую я там заакцептил, если договора нет и так далее, значит, я сам себе Буратино, сам буду нести ответственность перед тем, чьи данные утекли.
Все, принято, так, Денис?
Уголовка всегда классика. Если вы не уведомили своего заказчика, что вы будете использовать ИИ накосячил, а вы взяли за это деньги, значит, вы обманули своего заказчика. Это классика, статья 159 «Мошенничество».
Спасибо. Николай?
Ну, я тут душню по документам, поэтому читайте документы. Как правило, это будет нести ответственность за все пользователя. А тот, кто предоставил инструмент, он as is, ничего по умолчанию, никакой ответственности на себя не берет.
Who provided the document not the document, the tool. The document is provided as is.
По предварительному сговору, коллеги,
Everyone, I guess everyone will be found guilty. Right, thank you very much. Thank you for being with us. Thank you for withstanding this first time ever PhD legal session. I know that later in the day, Uma Thurman will be playing at PhD for the first time as well.